Carly Levin with the Legal Tech Fund, and I am here today with Natalie Knowlton, who is the Associate Director for Legal Innovation for the Rhode Center at Stanford. She works on legal technology, court modernization, and regulatory innovation, and she is a thought leader across everything that's happening across the regulatory landscape. We are very happy to have her here today because there's so much going on. So looking forward to hearing her insights. Natalie, thank you for joining us. If you don't mind, would you share some bit on your background and how you ended up in your current role?
Sure, and thank you so much for having me. I really, really appreciate being on. My Where I got to where I am was a bit of a walk, and a walk that I didn't know that I would go on necessarily. When I started law school, I did not want to be a lawyer. Wasn't sure what I was there for, but I was really interested in systemic issues. At the time, it was systemic human rights issues at an international level. But when I came out of law school, I fell into the academic, not from a faculty teaching standpoint, but from a research and advocacy standpoint. I fell into that world and became really wrapped up in issues that I hadn't learned about in law school, like the failures of the justice system, the legal services market that's breaking down, and all of these issues that really lit a passion in me to work for systemic reform across different areas in the US and then across the legal system more broadly. So I spent almost 18 years at the University of Denver at the Institute for the Advancement of the American Legal System there. I left there and opened a consultancy, Access to Justice Ventures, where my partner and I worked with and continue to some extent to work with entrepreneurs who are developing scalable legal innovation solutions. And then for the last year and a half, I've been at the Rhode Center at Stanford Law School, where I get to do a lot of the same kind of research and work on regulatory innovation, court modernization, and all the cool things that you introduced me as.
Great. Well, thank you again for joining us. In doing research, I've seen that there are specific experiences that you've had that led you to view access to justice as a structural market failure rather than a poverty issue or a affordability issue. Can you walk us through your experiences that led to that view?
Yeah, so first and foremost, being in the room with and reading the fantastic work of economists who are in this space. So I'm not an economist. I don't play an economist on TV, so I won't get into the definitions from that standpoint of market failure. But I highly recommend anyone who's interested in that read Gillian Hadfield. She's done a lot of great work on that. Her book, Rules for a Flat World, really walks through this in detail. But what I am most interested in from that standpoint is the lack of competition in the legal services market and then the lack of innovation that stems from that competition. And I saw, to your point about why is this not just a poverty law issue, I had the pleasure of working on a very difficult research project some years ago that consisted of qualitative interviews with self-represented litigants in family cases. And it showed, while it can't be generalized to the broader population and all that stuff, since it was just a qualitative limited scope study, what it really opened my eyes to is the fact that people make strategic decisions to be self-represented, not solely based on the cost of finding a lawyer. And particularly in family cases, we all know people have been divorced. Some of us have been divorced ourselves. You think about what happens when you or your ex bring on an attorney. It really ratchets up that animosity, and it brings new kind of sources of fear and new anxiety and new tensions into that space. And so when I was talking to litigants who were representing themselves in their divorce, a lot of them said it's just not worth it. I don't want to destroy that relationship with my ex-spouse. I don't want to have that kind of stress because then he'll get a lawyer. And so that really opened my eyes to the multifaceted reason that people proceed pro se. And there's been other research to show that it's not just about cost issues. It really runs all the way up the legal services market.
What have you, how has that changed your thinking?
Well, so
Once
I
you realize that, what did that lead you to do next or think next?
Well, to me, it's a system failure. And so we have to have system solutions. I forget what the maxim is, but you see that phrase everywhere that says that every system is expertly designed to produce exactly what it's producing. And so our current system, our justice system, designed by lawyers, meant for lawyers to navigate, not normal people who don't speak legalese. That system is effectively keeping people out of it. Now, courts are trying really hard to develop solutions that increase the availability of information and legal help. But still, we have this system that is meant for two lawyers that is now no longer accessed by two lawyers in the bulk, cases in state court. And so we need new solutions. We need new providers. Part of that is court simplification, as we've mentioned, but part of that is also new people who can come in and deliver legal advice and legal services beyond the traditional cadre of lawyers that comprise the legal services market right now. And so a lot of my work focuses on unauthorized practice of law reform to bring providers at the lower end of the level to do some of the work traditionally done by lawyers, helping people navigate forms and bankruptcy, or helping people walk through an eviction, 2-minute eviction hearing. So that's part of it. The other part is, how do we increase innovation in current legal structures and law firms? I've done a lot of work in modernization of Rule 5.4 ownership issues, creating alternative business structures. And I think there's some promise in technology developments through that model. I think we're seeing some of that, but it's still very early days.
Well, your work is just, it must be so complicated because you have to multiply it by 50 with all the different state rules. And I'm sure it gets multiplied beyond that. As you think about states that are doing the most interesting things in either non-lawyer representation or in non-lawyer ownership, which states come to mind as most
So,
interesting?
so I'm in Colorado, and then we always say that there's something out here in the water in the West because we're very innovative out in these Western states. And so I point to Utah and Arizona. They in particular have done a lot of interesting, pretty revolutionary things when it comes to like modernization of the legal ethics rules. Utah had erected the first U.S. regulatory sandbox for legal services back in 2020 now. And Arizona, as you mentioned, in 2020 also, they instituted a alternative legal services, an alternative business structures program that allows for non-lawyer ownership of law firms. And so those two states, they're the ones that have been moving further away from the traditional status quo when it comes to regulatory structure and framework. And I think, aside from what you believe with respect to private equity and law, or with respect to non-lawyers delivering legal services, I think they should be applauded, those two states, because they're really trying new things. They recognize that there are a whole subset of problems in the industry at different consumer levels, and they're trying something new. And maybe it doesn't work. And Utah, the sandbox is designed to collect data and information at a very granular level to shed insight onto what is working as what not. But I think they should be absolutely applauded for not sticking around with the status quo and for at least trying something.
Well, what is amazing about your work is that you actually look at that data and you use that data. So far, what has the data told you? What have you learned from it? What takeaways can we glean from it?
Well, I think a big one, and this is not necessarily surprising, but a big one is that there are certain reform levers that are going to lead to more access to justice focused outcomes. So when a lot of people, just caveat, when a lot of people say access to justice, they're talking about poverty law issues. They're talking about subsidized legal services. That's not how I use the term. I consider middle market and even high end market innovation to be access to justice measures. But when you look at the levers, the reform levers that are serving more of that low income poverty law access to justice consumer segment, those are really unauthorized practice of law reform. So Arizona didn't allow for that kind of change. Utah did. But we're seeing a lot of community justice worker programs coming up in Utah, a lot of non-lawyers integrated into law firms that are delivering legal services to individuals on the low level income scale. And so that does suggest that unauthorized practice of law reforms are key to serving those underserved populations.
Can you tell us more about any of those programs? What do they look like? How should folks outside of the state think about those non-lawyers?
Yeah, it's there's a lot going on in the space. It's probably the fastest moving regulatory innovation space out there right now. There are different tiered workers. So I think that the best way to think about this is think about your experience going to the doctor. Because until recently, we have not had that type of tiered professional structure in the law. We've just had lawyers, nothing else, maybe a paralegal here and there, but lawyers are bust. So think about when you go to the doctor. So if I make a phone call to my doctor, he's probably busy for the next couple of weeks, but I just said, I've got a cough, and so I want to see a nurse. So I have that option. I go and see the nurse. The nurse prescribes a medication for me to take for just a couple of days, but she wants to do a blood draw. So then the nurse sends me to the phlebotomist. The phlebotomist takes my blood. They send it off to a lab. And then one of the physician's assistants or CNAs will call me and share the results with me and answer some of the questions that I might have about my health and my test results. So all of that is such an integrated system that is really centered around me. Now, people can argue with how the medical industry is messed up and how customer service is not the best, but that's really centered around the patient, what I need, and what those providers are able to do for me within the context of my problem. Now, we're starting to see more of that build out in the law. So the nurses and the physician's assistants, those are kind of coming in at what my prior shop used to call the allied legal professional level. And these are mini lawyers in a sense. They are highly educated. They're often paralegals or specialized paralegals who have specific expertise and training in, for example, family law or a certain subset of the law. And they're assisting with forms, non-contested divorces, nothing that would really rise to the level of needing an attorney, but they've had 1,000 or so hours of training and mentorship. And they're maybe working within a law firm or working on their own, but funneling clients who they can't help to a law firm. So that's at the high end of this new tier. At the bottom, we have community justice workers who serve those more kind of phlebotomist roles, maybe CNA roles, and they're really targeted on a specific situation or a specific form or a specific client matter. The most well-known, of course, is Alaska, their community justice worker program, where those justice workers were helping Alaskans with SNAP benefit forms. They were found to be incredibly effective in their rate at helping the Alaska Legal Services client receive benefits. And we're seeing tons of data coming in from around the states. Now, this is really new data, but data that's showing that both levels that I've talked about are really effective in helping consumers.
So we've got the new non-lawyers representation. How does technology play into all of this? How are the states thinking about technology? How are you thinking about technology? And where's the priority? How are they working hand in hand? How does one replace the other?
So I've started thinking about technology, and maybe I'm stealing this frame from David Freeman Engstrom, who is he's the faculty co-director at the Rhode Center. So I'm just going to put that out there so it's not necessarily mine per se, but I've started looking at it in the context of mediated and unmediated technology. So I focus a lot on direct-to-consumer legal services and legal technology. And in that sense, I really do think about unmediated technology, which means that a user gets online and they get help with their divorce and they haven't talked to a single person, let alone an attorney. What I'm seeing the most is that mediated type of technology within the context of these new non-lawyer interventions. So someone will sit down with a client, maybe they have an automated form that they can work on, but they're working with that client. So they're still that human not just human in the loop, but human in the chair, mediating and helping clients work through this technology. So that's where I think it's really taken off. I think there are some states that are experimenting with unmediated technology solutions in the kind of subsidized legal service space. The North Carolina Legal Aid, I just have to give a shout out to them, and Cherie, that innovation lab. They're doing great things. So they have opened up a Leah chatbot. Her name is Leah, Legal Information Assistant, and she does her best to assist clients and non-clients with answering information about legal issues that might help them resolve or move some of their legal issue towards resolution before bringing on a subsidized lawyer through legal aid.
So you've got technology and non-lawyers, lawyers. How should the ethical oversight be structured? What's it look like today, and what's your vision for the future?
So today, I think we have a lot of interesting questions about AI and where that oversight is. On the non-lawyer and lawyer side, we have role regulation, and that's traditionally how we regulate lawyers in this country. That means that the regulatory apparatus is focused on that person, the individual who holds a license and an education. So that's often been the lawyer, but it's now in many instances for non-lawyers, it's those roles. But we're also seeing, and this relates to 5.4 experimentation in Arizona, we're seeing what we call entity regulation, where not just the individuals in an entity are regulated, but the entity itself is regulated. So the community justice worker programs are a bit of a hybrid role regulation and entity regulation. So in many of these programs, whether they're legal services organizations or community-based organizations, you have the overarching organization that is responsible for the conduct of these community justice workers within it. Role regulation, I think, also holds great promise for law firm legal technologies. So in Garfield in the UK, we have the first AI native firm that has gotten regulatory approval. And so that, I think, is a really promising way here in the US for regulators to cover legal technologies. And just one more thing, the Utah Sandbox, I point out, also provides for that role regulation and entity regulation of legal technologies within an entity that's authorized in the sandbox.
What's the biggest misunderstanding around this space? What, if you could correct one statement that you hear too often, what would that be?
Well, it's the wild, wild west, which is, kind of ironic because it's in the West and the states are often considered the wild, wild west. But these are such heavily regulated environments. I don't think people appreciate that. I have read through the application materials of about 140 Arizona alternative business structures and about 40 different applicants who sat in the Utah Sandbox at one point. The information that people have to provide at the outset, the kind of testing rubrics for their service models they have to provide, the disclosures of past litigation. It's essentially a character and fitness requirement that not only every individual, but every entity in Arizona that co-owns an ABS law firm, it is incredibly regulated. And then beyond that, once you're in the system, you have routine reporting requirements. In Utah, depending on your risk level, that might be every month or every quarter. In Arizona, you have to reapply for a license every 2 years now. It used to be a year, but now it's every 2 years. And in that application, you have to make certain disclosures. And in addition to that, you have to have a compliance lawyer in Arizona who's submitting very, very detailed compliance reports periodically, I think twice a year, that talk about anything from M&A activity to new investors to training programs for the lawyers and the non-lawyers, compliance issues, consumer harm, consumer complaint issues. And so none of that really exists for law firms. We don't have that kind of heavy regulatory structure that we put on law firms in this country. And so the biggest misconception is that these are just folks gone wild with external capital. And that's absolutely not the case.
If there are law students or law firm associates who are listening today, what should they be thinking about? What's your best advice in this new regulatory environment? What ideas do you have for them?
Well, pay attention, certainly. This market is moving faster than I can keep up, and it's my job to keep up with it. So find good sources of information and follow that. Understand what's happening. At the very least, if you understand what's happening, you won't be confused by it when it happens to you. And for law students, that means when you get in the market and realize that things have changed from what you've learned, or the system, maybe the market is not what you thought it was going to be, which is particularly true for people who want to serve consumers in that people law segment. But then for partners and associates in law firms, one of the things that I hear a lot of people saying, and I think it's really true, is that your competitors out there are thinking about all kinds of ways to eat your lunch. And they're gonna do it. And so at the very least, knowing what's happening and being aware that it could be happening to you at some point or could be forced upon you will at least position you to move, preferably before that happens, but at least to be informed and reactive when it does happen.
Well, I'd love to hear what sources you would recommend to folks to follow. And then what data do you follow? What data is most interesting to you? And what data do you wish you had that you have not seen to date?
So I follow the data that the regulators put out, particularly with respect to Utah and Arizona. So the Utah Sandbox will be closed. It will have concluded its 7-year pilot period, I believe, next year. And so I'm looking forward to what the regulators are saying there. Of course, the Rhode Center has put out a few reports now in Arizona and Utah. The Institute for the Advancement of the American Legal System, too, has put out a series of reports on the Utah Sandbox that I highly recommend. Also, I think in terms of research that I wish we had more information on consumer harm. Now it's difficult to look at Utah and Arizona because they're measuring consumer harm in different ways. But I wish we had, for example, Utah has very, very granular consumer harm at the service level. And so when you're looking at normal regulatory data from a state on attorneys, you're looking at number of complaints, number of disciplines, those kind of like attorney level metrics. In Utah, you have actual service level metrics. So how many services a company has issued to people and whether that particular service resulted in harm. That kind of granularity is amazing. Now, will we ever get it? No, because Utah lawyers and Utah law firms and lawyers and law firms across the country would throw up their hands and say, absolutely not. But if our goal is really consumer protection and monitoring consumer harm, then I would suggest that's a framework that we should all start looking at. In addition to that, I think what we're missing are stories of clients. Now, there are people who dig up stories of disgruntled clients, and you're going to see that across industries, and you're going to see that within and without regulatory frameworks across the state. But we really do want to understand, are these new models impacting clients in what way? Are they benefiting clients? Are the services becoming cheaper? Are they becoming more expensive? Are the services becoming worse? The enshittification of legal technology and legal services, are we seeing that? So these are questions that are not unique to these new regulatory environments. They're unique to the market as a whole. But I think because there's so much pressure on these new non-lawyers, on these new structures of law firms, there's so much pressure to ensure that consumers are not harmed from them that we could start there.
Since you brought it up, what does the data show so far on consumer harm?
In Arizona, what we have to go on are regulatory actions that have been taken by the Supreme Court to date. There have been 2 disciplinary orders issued against ABS entities, and then also 2 separate orders issued against the compliance lawyers in those entities. Then, and I have not done comparative look at how that tracks with just law firms in Arizona in general and lawyers in Arizona in general, although I'm thinking about what that assessment might look like. In Utah, it's pretty minuscule. I think there are some issues with respect to the reporting from the court. So we don't have up-to-date information on that. I don't, at least. But when we put out our assessment in last June, I think we found 1 in 5,000 or so instances of consumer harm by service delivered. So, that's seems like a very minuscule amount. I would love to see that again for lawyers and law firms in Utah more generally, but we don't have that.
Yeah, that would be a wonderful comparison. Reminds me of the automated driving and versus human driver comparison.
Yeah.
If you look out 10, 15 years, what do you think the legal landscape, structural landscape will look like? What's your best vision?
My best vision is one in which technology has been responsibly deployed to help move down market for law firms so that they can serve more people who might need reduced fee legal services or who are just cost conscious in how they want to consume legal services. And also that there are non-lawyers embedded appropriately in law firms and organizations who are capable of taking some of that more rote routine work off the hands of lawyers who have been appropriately trained and educated to do that. That's my best vision, but what I fear, the more accurate vision, is that not much has changed.
Well, thank you so much for joining us today and having this conversation. It is broad ranging. If folks want to read more about what you're working on, where should they go?
You can find me on LinkedIn, Natalie Knowlton. You can also find me on Blue Sky or what used to be Twitter at NATALALLEYCAT, Natal Alley Cat. And also feel free to reach out to me on either of those platforms.
Great. Thank you so much for joining us.
Thank you. Thanks for having me.